Okay, I am reading chapter 5 of the Civil Rights Law Casebook by Samuel Bagginsos. I'm on page 564. The discussion is private housing and public accommodations, which is Title III of the ADA and the Fair Housing Act. I'm in section E of this chapter titled Remedies. The introductory notes talk about how Title III will provide injunctive relief for a private cause of action, but the Attorney General has to take the case in order for a plaintiff to receive monetary damages, compensatory damages. And first off, there needs to be a pattern of violation of Title III discrimination, and the award would be $50,000 for a first offense and $100,000 for a subsequent offense. And this is made by way of incorporating the Civil Rights Act of 1964 into Title III of the ADA by reference. And however, the Fair Housing Act does not have the same restrictions. A moving party can be granted, whether it's a private or a public cause of action, can be granted injunctive relief, actual or punitive damages. So now getting that out of the way, and that was part of the introductory note, I'm going to get into the first case under part 1 of this section titled Standing and Pleading Requirements. And the first case is titled Naiman v. New York University. Plaintiff Alec Naiman, who is deaf, was a patient of New York University Medical Center, a medical facility operated by the defendant, New York University, on 4 occasions between February 9th of 1993 and October 18th of 1995. Naiman alleges that NYU provided him effectively excluded him from its medical facility because it failed to provide him sufficient sign language interpreting services during his visits. He seeks monetary and injunctive relief under the Americans with Disabilities Act, the Rehabilitation Act of 1973 as amended, and state law. NYU moves to dismiss Naiman's first amended complaint pursuant to Rule 12b-6 of the Federal Rules of Civil Procedure on the grounds that Naiman does not have standing to seek injunctive relief. And this is being heard at the United States District Court for the Southern District of New York. So I think that this is a district court level, not under appeal or anything. So on February 9th of 1993, and again on November 16th of 1993, Naiman was seen at NYU MC for an excruciatingly painful kidney stone attack. Despite Naiman's request, NYU MC failed to provide Naiman with a qualified sign language interpreter. On the November 16th, 1993 visit, after Naiman had been at NYU MC most of the day, NYU MC eventually presented a person with minimal ability to communicate in basic sign. This person was, in large part, unable to understand Naiman. On October 3rd of 1995, when Naiman was again a patient, NYU MC failed to provide him with any sign language interpreting services. During the 4th visit on October 18th of 1995, NYU MC failed to provide such services in a timely manner. So Naiman claims that he requires a sign language interpreter to meaningfully participate in his own medical care. Naiman also claims that NYU MC's failure to provide a qualified interpreter denied him the effective communication necessary to allow him to communicate with doctors and staff. Naiman allegedly continues to suffer as a result of never knowing whether NYUMC, when rendering medical services to him, will be capable of effectively communicating with him. To establish that he has standing, Naiman bears the burden to establish 3 elements. So these are the factors for standing. First, the plaintiff must have suffered an injury in fact, an invasion of a legally protected interest, which is a concrete and particularized, and B, actual or eminent, not conjectural or hypothetical. Second, there must be a causal connection between the injury and the conduct complained of. Third, it must be likely, as opposed to merely speculative, that the injury will be redressed by a favorable decision. Well, that's awesome. There's 3 factors. I feel like this is also a rule of civil procedure. I might just be making that up because I haven't taken civil procedure yet, so that makes this a little hard for me. Lujan versus Defenders of Wildlife. This is a case used in the analysis from 1992 regarding the injury in fact requirement, which is the only element of standing at issue on NYU's motion. Okay, so this is also the issue. So the standing is the issue in this case, being brought before this case court. Past exposure to illegal conduct does not itself show a present case or controversy regarding injunctive relief. If unaccompanied by any continuing present adverse effects, is probably a holding from the Lujan versus Defenders of Wildlife case, which I suppose is also supported by the City of Los Angeles versus Lyons, quoting Shea versus Littleton. And thus, in order for Naiman to have standing to seek injunctive relief against NYU, he must allege facts sufficient to demonstrate a real or immediate threat that he will be wronged again. So yeah, we're talking about actual or eminent, not conjectural or hypothetical, which I feel like what they're establishing here is that his standing isn't likely sufficient evidence. NYU argues that the 4 incidents alleged in the complaint, which NYU describes as intermittent visits to the emergency room over a period of years, are insufficient to demonstrate a real or immediate threat that Naiman will be wronged again. NYU contends that Naiman has failed to set forth sufficient facts in his complaint to show that the bouts of pain he has suffered are very likely to be repeated and to necessitate emergency attention at NYU Medical Center. All right. So are 4 instances insufficient evidence of presentability factor? That's the counter argument being analyzed here. The instant case is distinguishable from the cases NYU cites in favor of dismissal. In the majority of those cases, there was but a single alleged discriminatory incident, and thus the plaintiffs failed to show that they were likely to be harmed again. See Lyons. Okay, so case law suggests 1 incident is sufficient in Lyons. Allegedly illegal chokehold performed by arresting officer is the facts of that case. And in O'Brien versus Warner Bus Lines, the blind plaintiff did not have a standing to seek injunctive relief because against bus company that refused to allow plaintiff's guide dog onto bus where company among other things, issued public apology, provided plaintiff with free bus tickets, and directed its bus drivers to admit guide dogs onto buses. Right, so for those reasons, it's more likely that re-injury is unlikely. And in another case example, Atakapa versus Perimeter OBGYN Associates, in the Federal Supplement, 1994, pregnant plaintiff did not have standing to seek injunctive relief against clinic that required HIV screening where plaintiff sought treatment elsewhere. And in Homeful versus Barlow, prospective surgical patient with AIDS did not have standing to seek injunctive relief against doctor who said that he would not touch AIDS patient with 10-foot pole, where doctor later said he would conduct the surgery and plaintiff received surgery from different doctor. In Akins v. St. Helena Hospital, in 1994, a deaf plaintiff did not have standing to seek injunctive relief against hospital, which failed to provide effective communication to plaintiff, who arrived in emergency room because of husband's fatal cardiac arrest. Farmland Dairies versus McGuire of 1992, the plaintiff failed to show that commissioner would again issue orders which court declared unconstitutional. Therefore, Naiman's allegation of 4 visits to NYUMC in which NYUMC failed to provide him with effective communication are sufficient for pleading purposes to demonstrate that if Naiman were to go to the NYUMC again, it would again fail to provide him with effective communication. However, this is not enough to satisfy Naiman's burden to demonstrate standing to seek injunctive relief. Naiman must also show a real or immediate threat that he will require services in the future, although the court concludes that Naiman's first amended complaint fails to allege facts sufficient to demonstrate standing to seek injunctive relief against NYU. The court grants Naiman leave to amend the complaint within 30 days of the date of this memorandum in order to satisfy his pleading burden. And so because there's that second prong that you have to show that you're going to go back, that's probably why you see in some of the cases cited here where they got a surgery elsewhere that they're not able to meet that second prong and therefore didn't have standing. I'm going to break before going into the next case in this section.